So it's 2:47. I'm reconvening our meeting, and we will go back to our discussion. I would say, based on the comments before we heard Ms. Chang, that we really perhaps, which I think really kind of goes back to what Dory said initially, is we really have sort of two perspectives. One is a current system with some evaluation and perhaps some minor adjustments, and then a desire by some to think about doing something more significant. Did not hear specifically whether that, and I haven't really heard, to have two separate, but to perhaps have under an umbrella something where you have the regulatory side on one side of the house with mandatory fees, and the voluntary on the other side of the house with voluntary fees, and maybe different governance depending on which side of the house you're on. But that might be more detail than people have thought of. But we can send more than one recommendation to the Supreme Court. If we have a consensus or unanimity on one, then of course that would be the one we would send. At this moment, I'm not hearing unanimity, but I am hearing kind of two sets. And I think, from my perspective, either of those would require us kind of looking at the various functions that the bar currently does and putting them in, well, I think a couple things. One is some things I think are just obviously regulatory, discipline, admissions, MCLE reporting. I know Fred has a proposal to be sure the Access to Justice Board and equity, diversity, and inclusiveness would be considered on that mandatory side, which may just be what we currently have and still be there. But if we were to go to something else, desire that just be clear that those are on that side. I think where you see the more voluntary side, of course, is where it is currently, which is in the sections, and maybe some of the bar committees. Sections currently people pay separately for that. I know the bar has overhead and has allocated based on all sections, not just looking at big sections who might use a lot of resources and little sections that might use a lot of resources per member amount. But looking at the materials we received, there's still additional money going to that cost center for sections. So at least the materials I reviewed don't show that they are completely self-sufficient. And if we just are making little tweaks, then of course the sections would still be there. And if we were doing separate, then they might go into, I think they would be more naturally on a voluntary side. I'm not really myself personally, I'm not really wanting to have two separate organizations because I think all the concerns that people have are there, and I think there is an advantage of sort of not cutting half of what, or some percentage of what has been the Bar Association free, because I think then they just, that might be more than they could absorb. I thought it was really interesting to listen to Emily Chang and her perspective and having heard the other speakers. So I guess my thinking is maybe we can have some discussion if people want on what they heard from Ms. Chang, and if that changes anything you're thinking or supports what you're thinking, and then start thinking about how to best approach our discussion of what we would want to recommend to the Supreme Court as to the future WSBA structure, whether that's what we have with some changes or something else, and more specifically what that would look like, because what we've heard is sort of a desire to do it, but I actually didn't hear any specific details, for example, from Hunter as to what that looked like. Hunter, please.
Over the
yes,
mic
I
button.
see it twitching over.
Well, thank you. I did kind of want to provide some broad outlines of my thoughts earlier and then maybe dig a little bit deeper into the nitty-gritty. And really for my toolbox in this analysis has been the memo that Chief Justice, your clerks, put together as far as looking at some of the different models that are out there. I just find that extraordinarily helpful. I believe it's on. Can you not hear me? Oh, sorry. Thank you. Great, thank you. Yeah, I thought the memo prepared by the Chief Justice's clerks were extraordinarily helpful, and it looked at the structures for a number of states, including what we have currently. It looked at California, which has recently undergone the transition from a unified bar association to effectively two organizations. One's called the California State Bar that operates under the judiciary, and the other one is the California Lawyers Association, which is the voluntary association. It looked at Virginia, which has what I call the two-bar model, the Virginia State Bar and the Virginia State Bar Association, which I've always frankly found to be confusing and kind of unnecessary. I'm not sure if that would be, in my mind, the best way to structure it. And it looked at a couple of other states that are out there as well. And in looking at those and thinking about them, I think it might be ideal to look at going to something similar to what California has migrated to. I would like to avoid what I call the two-bar model because I think that lends to confusion for not only the members but also the public. But then having the core regulatory functions operate under the judiciary with some sort of an intermediate structure there. Again, the justices have day jobs. And I think it is important to this concept of a self-regulated profession to have members of the profession serve on some sort of governing board for those regulatory functions. And how those individuals are selected, I think that's a fertile area for discussion, whether it's direct appointment by the court or whether it's some sort of an election process or a combined process. I think that would be an interesting conversation to have. But then the other entity that would exist, I guess, in my mind, ideally, would be some sort of a purely voluntary organization. And I think it's important to squarely acknowledge what the likely effects of that would be. I mean, I agree with Paul that the sections are really, in many ways, the lifeblood of our organization. And it's really the connection that a lot of people have to the WSBA. And if we were to go to a voluntary organization that the sections were a part of, I think what it would mean would be a leaner organization where it's operated by the dues that are paid by the members who want to belong. It likely means a reduced organization. I just think it's going to likely result in less funds, which means the ability to do less things. But at the same time, that illustrates the problem that we currently have. It exists currently with the structure that it has and the footprint that it has currently by virtue of the fact that everyone has to belong to the organization writ large. So I would be in favor of some sort of a modified California approach. And really, one of the things we've been talking about is where do we draw this line? What is included in the regulatory side? What I would envision as still having a mandatory, belonging under the judiciary in which everyone is subject to, and what would belong to the voluntary. I guess we can spend our time trying to figure out for us what falls on each side of the line, but that will be time intensive. And we do have both experts here at the bar who can spend time to think about this later on. It may be putting, in one sense, the cart before the horse if we go through each of our functions and recommend what falls on each side of the line. It might be something we could think about later on if there was a desire to go down the route that I'm proposing. Just counting heads and listening to people, I'm not sure that that is there. But the name of intellectual honesty, I think, is important for me to throw out where I'm at currently, acknowledging we do have more meetings, but those are my thoughts.
Andre, next, and then I'll go to Fred.
First of all, I thank Hunter for putting his thoughts out there. But also, I'm struggling coming back to the race. What is it that we're actually trying to accomplish here? Our charter is to review and assess the structure in light of recent case law and First Amendment and antitrust implication cases. I think it's clear that, Ms. Chang made it clear that we shouldn't make any knee-jerk reactions to that. So I think we can check off one. But in checking off one, we still are mindful that there are political wins and potential cases that could come our way. But I don't think that affects the structure of the Bar Association itself. Now, I'm also struggling with this use of analogy of Janus to bar associations in considering First Amendment speech. And I go back to a holding in Keller that concluded that indicated that concluding that applying labor union tests to bars would impose a massive burden on analyzing all proposed activities under vague and uncertain standards, designed for an organization with quite different purpose and structure, and probably discourage bar from carrying out its statutory functions. And so we have a pretty robust set of regulatory objectives that include diversity, inclusion, access to justice, and Judge Corbett did provide his resolution, but I think your resolution is already included within GR 12. And so, I'm struggling with all these different drop-down boxes that we're going in, because it really comes down to, if it isn't broke, don't fix it. I'm not in the do-nothing section, but I'm kind of with Paul. If there's something that we can tweak, let's tweak it, but let's kind of clear out all the noise and all the analysis about Janus, because Janus isn't a threat to us now. The third thing that is on the charter is, I think, the additional responsibilities of the WSBA due to its administration of the Supreme Court appointed boards. I think it's important for this board and anybody watching to understand that the North Carolina dental lab case with teeth whitening, they got into trouble because they were sending out cease and desist letters to market participants, and they didn't even have a definition of teeth whitening that was spot on to the practice of dentistry. What we've done in the practice of law board is we've rewritten the rule to be consistent with our charter, our reconstitution in July of 2015, I believe, to remove any antitrust activities. So we're already actively engaging in that. So again, First Amendment, antitrust implications, I don't think we need to make any concrete recommendations for change. Hunter, you're talking about recent reorganizations. I'm curious to know why California did what it did. And then my third point, again, let me go back to that, is the administration of the bar. That's a governance issue. We haven't been talking about the governance issue. We've got governors on the board. We've got new elects on the board. There was a task force, a governance task force in 2015. Right, wrong, or indifferent, some of those recommendations were adopted and some weren't. We're at our last meeting and we're just starting to talk about governance. Where are we going with this thing? So I'd like for us to kind of move on. Let's get some concrete consensus with respect to First Amendment implications. And I know, Eileen, that's an exercise in taking out all different functions, the sections, and looking at their cost, and Julie provided the First Amendment implications and all of that. That is a heavy lift, and I think that's outside the scope of our charter. But it doesn't mean that that's not important work that shouldn't be done. So coming back to my third point, and that's governance. Is there a need for change in structure of the Board of Governors? Should these individuals be appointed? What type of additional oversight is needed from the Supreme Court with respect to decision-making in relation to employment issues or other decision-making and rulemaking? That's where I would like to steer our conversation if we are able to come up with some consensus with respect to the first two parts of our charter. So I invite any additional comments, but that's where I sit at this point.
Okay, I had Fred next, and then Mark. Okay, Fred, you're next.
Much of what I'd say would be to echo what Andre said. I wanted to start as well with the charter. And, you know, we're to review and assess the WSBA structure in light of, the first point, recent case law with First Amendment and antitrust implications. I think we've had the experts testify to us. we've had, or not testify, speak to us, and we've read the articles. We don't have to make significant changes. We don't have to bifurcate the bar. And when we started this process, I don't think any of us were sure that that was the answer. I think we have gotten to that point. We don't have to make a change. So now the second part, let me go to the third point. The third one was the additional responsibilities of the WSBA due to the administration of the Supreme Court appointed boards, which would include the Access to Justice Board. If you read some of the comments, some of the people that want change at the Bar Association don't want an Access to Justice Board, don't want disciplinary counsel. You know, they haven't gone so far as to get rid of the bar exam, but they don't want anything. And I think, I don't know, Andre, if you said this or not, but I do think there's some things, whether it's said in GR 12 or not, I think we need to reiterate that that is something that needs to stay. And tying that back to the first point, I think it's very clear, based on our constitutional scholars that have spoke to us, is that we do not have to eliminate diversity, inclusion, and access to justice materials. We can make that conclusion, and I think that that fits within point 1 and 3 of our charter. The second point, also, you know, looking at what we should look at, what are other bar associations doing? I'm not quite sure that California, what they're doing, and I'm not sure that California really knows what they're doing. And at this point, I see no compelling reason to try to follow California's model without much more study. So I'm coming down in the Paul camp as well on this is, let's look at some things that, as we've gone through this, that can maybe make people a little happier. Be careful about our budget. Look at the opt-in versus the opt-out, those type of things. Thank you.
Mark, you're next.
I agree with Andre. I think we're 2/3 of the way through our work, and I stated another way, I do not think we would be here just because of Janus. I think we're here because of governance issues that have been raised, whether the arguments are good, bad, and different. That is the 800-pound gorilla, or however big that gorilla is in the room, and we have yet to have a meeting on just the governance issues. I think we've vetted the bejeebers out of the association and free compelled speech and so forth. But I would like to see, if Madam Chief Justice would consider it, that we just have a meeting where we come in nice and fresh and we talk about the governance issues that I think were the primary mover for us being here. And so as long as it's not July 17th, because I'll be in trial, but I would like to participate in that meeting.
Okay, others? Eileen?
Well, we'll probably all quote from Keller before this is over, but it, as Emily said, Ms. Chang, that is good law, but the law, it says, is you may constitutionally fund activities germane to the goals out of mandatory dues. It may not fund activities of an ideological nature which fall outside of those areas of activity, which are the regulation of the practice of law and the improvement of the equality of legal services. The guiding standard must be whether challenged expenditures are necessarily or reasonably incurred for the purpose of regulating the profession or improving the quality of legal services. And then the court lists 4 statements made by the State Bar on issues related to gun control, something about victims' bills of rights, nuclear weapons freeze, and abortion. Well, this State Bar, if you want to go to governance, has on at least 2 occasions taken ideological positions. I don't know how far you have to go taking those positions to run yourself into real trouble, but it's an issue that needs to be addressed. I also don't think it's fair to tag the commenters with the most extreme of those who have commented. One of the Board of Governors members, I think is here, who has suggested that you can have an integrated bar, but to go back to, there is a path you must follow in terms of explaining how you are spending those bar dues. And I believe that was, what was that? Oh, license fees, thank you. The money. I think Mr. Eric Stahl, who I took the time, also said that's the same course. When I spoke to Ms. Chang, the mushy ground is something that you have to at least show you have made an effort in good faith to negotiate. And we've just heard from bar staff on issue areas that have possible First Amendment implications, and I think we cannot ignore that. And no, this group doesn't have the capacity, the time, et cetera, to analyze the activities of the bar, but somebody needs to do it. And my recommendation to the court, because it's the court that's ultimately going to do things, is that it, either itself or with an outside party who probably will have to be paid, conduct that examination. That would, I think, both provide credibility and transparency for bar members and offer you some response if or when there is a lawsuit. I think it will also influence or be part of or should be part of a governance discussion. I think that although Ms. Borboa has not, because she's working with the lawyers who are volunteering, heard a lot of dissatisfaction with the bar, I think there are strong feelings about the Supreme Court creating boards that bar members are required to pay for. And it's just better to deal with that up front and to discuss it rather than to say we're just going to ignore it and move on.
Others?
If I could jump in really quick, I may be stealing your thought, Fred, but Eileen, that's a different question. It's fundamentally a different question of looking at the costs of the boards and looking at an a la carte menu for bar members.
If you're going to have an a la carte member, you're going to have to put your costs somewhere, right? What's going to be optional?
I've read all of the materials that the bar has provided to us. It's pretty transparent where the money is going.
No, it isn't.
Well, I think we have this in the mandatory versus compared to non-mandatory programs. I think that's somewhat illuminating. It's only, well, not only, but it's $5 million to the non-mandatory stuff. And if we want to take a look at that, I think, again, that goes outside the scope of our charter.
Well,
And so I'm just trying to, because we're at our last meeting, our last scheduled meeting.
actually,
So-
we're not. The Chief Justice has announced our second meeting, and I was following up on Mark's point,
I
which
understand,
to
but
broaden the
but-
scope. And we will have to agree to disagree.
Understood. So my final point is, I don't understand, are you looking at an expansion of Keller, or are you looking at a digger, because that's what Ms. Chang had indicated, that maybe the Keller deduction is something that we could continue to examine, which is fine.
Mm-hmm.
But if we're still talking about examining the First Amendment issues under Janus, I think that ship has sailed. I think that's risk that we have, and we're not going to be able to shore that up.
I think we're talking about looking at the First Amendment issues under Keller.
I was going to actually ask Eileen a clarification question when she said that, when you suggested that we recommend to the court that they conduct an exam, and that's really of all of pretty much what Julie outlined as things that could implicate speech under Keller. And I think speaking for myself, which I try not to speak, because I know every time I speak, everyone says, oh, that's what we're doing, and that's not what I want you to be. I don't want that to be your reaction. I understand that I'm just one of many of you at this group discussing, but that is what you were saying was under Keller. Okay.
Yes.
So does anyone else wish to speak? Fred? And then Hunter, and then I want those who have not spoken to have that opportunity. I want to see if Kyle or Mark, I already had you on the list. Did you speak when I already called on you before?
I believe that I did, but I wouldn't mind speaking again.
I'm going to put you back on the list, but you're going to be after Fred and Hunter.
That's fine.
Okay, and then I want to see if Kyle, but then after they have spoken, and anyone, and Dan Clark, after they have spoken, Those who have not spoken, I want to give a chance to speak. And if they do, that'll be great. And if they don't, they will pass. But I think based on our conversation, we can probably reach a consensus on perhaps the first and maybe even the second issue as to how we feel about the impact of Janus and the other, or at least have some language offered that we can vote up or down and sort of see where people are. Fred, you're first.
Eileen, I don't know whether it was my inarticulate nature, but I don't think that Andre and I are disagreeing with you on important points. Keller's the law. I think we've listened to this, and I think it's important that we follow Keller. And it doesn't mean that, I've used the word robust or whatever, but we've got to continue, and we recommend the Supreme Court that we carefully look at Keller and make sure that we follow that. And I don't think we're going to be able to decide here each little piece that goes in or not, but we have to have, the conclusion is Keller is still good law. We can still do a lot of what we've done in the past, but to be responsive to the public and our constituents, we should look at, the opt-in and opt-out and make sure that we're spending our money wisely. So I think we agree on that. And I hope that we agree that access to justice and those issues, and maybe we can get a vote on my resolution at some point today too, as whether that's one of the first things we can decide is that still something that we're going to include in our recommendation to the Supreme Court.
All right, I have Hunter.
Okay, well, I just wanted to offer a couple of quick thoughts. First of all, I have to say I'm enjoying this conversation. I think we're getting into the nitty-gritty here, and it's neat to see the discussion move along down this path where we are arriving at forks in the trail. Fred made a comment maybe a few minutes ago that I just wanted to briefly respond to, which is that, and I believe Andre referenced this as well, is that we are not compelled by Janus to be rushing into making any sort of reactive decisions about the structure of the bar. And I mentioned earlier, and I want to reiterate, that I think we should be thinking about, for us, what is the optimal structure of the bar at this time for our state in 2019. And I am not as confident as some other individuals and some speakers that the Janus exposure is low or potentially even non-existent. I think there is exposure there. Undoubtedly, there's a constitutional issue there. Regardless of whether or not it survives review under Janus, there is a constitutional issue there. We are told that on a regular basis by members. And so what I would say is we may not be compelled to make a change by Janus, but my point is I think we should do it as a positive good, transition to a different structure for the Bar Association. And I threw out the California model. It's actually representative of the models of a number of different states, but I threw out California because it's a state that recently made this transition. It has not been perfect, but it has made this transition. It shows it can be done. And I think just saying, well, the California model, I think misses one of the bigger pieces, which is it's not just the California model, it's the model that with some variations exists for the majority of states in this country. The majority of bar associations in this country have decided that this is the better model for their members. And I believe it would be better for us to build trust with those three constituencies I talked about before, the public, the members, and the court. Thank you.
Thank you, Hunter. Mark.
Thank you, Madam Chief Justice. When Jean spoke, she gave us a kind of a background on what she perceived and perhaps the WSBA administration perceived as speech-related activities. And we have also used time and time again here the terms mandatory and discretionary or mandatory and voluntary. I think those two, if you frame the issues that way, yeah, we have a problem. But that's inappropriate to frame the issue that way. And everything is speech. The law was built on argument. The law was built on people taking different and opposing points of view. And so that is, the issue is what our Supreme Court, empowered with the constitutional authority it has, what our Supreme Court decides is an activity that is reasonably related to the improvement of the quality of legal services or the regulation of the practice of law. That's the issue, not this voluntary mandatory thing. That's the issue. And our Supreme Court has determined that as a privilege, as a condition of the privilege that I have as a lawyer practicing law in this state, that I can, and I do consider it as a privilege, I can support access to justice. And I have the structure around me to do that. That is a privilege. That is why I became a lawyer. I didn't need any help. I'm a white male. And I was born with the best, sharpest blades in the hockey arena. I've slid through life. Okay? If I can't take the education that I was given, and if I can't take some of my money to support people who are disadvantaged in achieving equal justice in a democracy, then I ought to take my damn license and tear the thing up. And our Supreme Court has told us that that is an obligation. That is an obligation. And that's the issue what we're talking about. What our court believes is the right thing for us to do to improve the quality of legal services, to extend a helping hand to the disadvantaged who may not have access to justice like we do. And we should be proud of doing that. And we don't need to change that because our court has all the power it needs to do what it has done. So if the court wants to change that, if the court wants to dismantle our access to justice program and set us back 30 freaking years, they can do it. But I don't think our court would, and I don't think that we should allow this improperly framed issue of what speech. Of course it's speech. Everything's speech. If I read an article in the Bar magazine, and there may be a reason, Paul referred to the Bar magazine as low-hanging fruit. I think it's maybe anachronistic now in this day and age to have a written magazine come out every month. There's a thing called the internet, which might solve that problem. But if I write an article on something that has ideological implications, the magazine is there. The absolute singular purpose for that magazine is for somebody to write an article and oppose me. That is how the law develops. There's nobody shutting down any voices in that magazine. If you want to take the time to write an article, write it. So let's frame the issue properly, and I think it's been answered by our speakers, and I think we can move on, and I think we ought to get on to the subject of bar governance, which is what got us here.
Okay, Dan Clark.
I really agree with that, Mark, and with Paul and Fred and Andre. I think we should keep the bar structure as is and do some tweaks to it for Janice and to strengthen things. But I would like to call for a vote today on that we keep the unified bar structure as our model.
Okay, thank you, Dan. Anyone who has not spoken who wishes to speak from the work group? Kyle or Jane?
This is Jane. I've been listening, and it's been interesting to try to keep up with who's where because I couldn't get the internet to let me see people. But I agree with especially Mark with his last statements that being a member of the bar is a privilege. And I think that, yes, there are definitely some things that needs to be tweaked in the bar and in how they operate currently. There's always ways to make cuts. There's always going to be people that are going to want their sacred cows to be gone forward and not, or them thinking that other people should be able to cut their monies. But I think overall, I agree. I haven't heard really anybody that I've talked to that has really disagreed with the bar or is really unhappy with the bar. I know there's a lot of, I shouldn't say a lot, but there are people out there who are firmly angry with the bar and how they do things. And like it's been said, I think this is good for discussion. It makes everybody sit back and think what their position really is. So I'm kind of in the camp, too, of I think the bar structure should probably pretty much stay the way it is, but I definitely think there's some tweaks that need to be done. And I kind of agree that maybe some type of outside entity maybe should come in and evaluate it. It's, always nice to look at it with fresh eyes. And, even as a court system, we've had people come in and evaluate our systems where we think they're great, but someone with fresh eyes can come in and say, well, you're okay, but you could do something here in this area, or you're not maybe doing something as well as you could be in another area. So I think that's kind of where my position is on the whole thing is let's look at it with maybe some fresh eyes, but I really think that if we do something drastic, it's just going to create a lot more problems than what they're going to be solving. And again, even when you do all of that, a lot of people are still going to be unhappy with it because we can't please everyone.
Thank you,
That's
Jay.
all I have.
Kyle?
Yes, I've got a couple comments. I agree with most of the folks that I've been hearing about not making drastic changes, as I've said before. I also don't think, with all respect to Hunter, that California is the model that we want to follow. California's got 200,000 attorneys, and Washington is a much different bar than that. So in my mind, that would be a dramatic change that I would like to stay away from. The other thought that I wanted to share is in the last year and a half, as I've been talking to folks around the state, whether that be senators or representatives, and we've testified before the legislature, or in these speaking tours, the problems that folks think that there are in the Bar Association or the Board of Governors, some of these things go back many years to different Board of Governors and different folks and different presidential administrations and things that have happened years in the past. And so I think we want to be careful about saying, a current board needs to be restructured because of the things that are going on right now. The things that I heard when talking to folks are, one, what I mentioned before, it being a Seattle-centrist Board of Governors and an organization. And, in the last few years, we've had, presidents from Spokane and Bellingham and Yakima, and, we're not so much that much anymore. We may go back to it, who knows. Most of the attorneys are in the Seattle area, so, we don't want to say we're not involving Seattle, but that was one of the biggest things that we were hearing. The other thing that we heard was the referendum process from several years ago that was disrupted over the fees. That really isn't a current issue. So if we're trying to please some folks who are concerned about the governance, you're going to need to go back many years to determine what those things are and make some changes. And I think that would be, we need to be very careful in doing that and figuring out exactly, where the anger is coming from and how to solve that. And as folks have said before, you're never going to please everyone. I think, reorganizing, the structure, I think it's just reorganizing the chairs. I think it would be helpful. I'm happy to have that discussion. But, what you think is important and is angering members, maybe not it entirely. It may be something that's much more deeper and from several years behind. So those are my thoughts.
Thank you, Kyle. Anyone else from the work group? Would you like me to entertain comments from those who are present, or do you want to keep moving down the list of trying to get some resolution today? Mark?
Well, I think Dan had a motion.
Was there a second?
I second it.
Oh, just right now.
Yes.
Yes, okay. So Dan's motion was to keep this bar structure as it is currently and make tweets. I wrote tweets, but make tweaks. Very close. I'm sure we'll get tweets about our tweaks. But, all right, so I have a motion from Dan Clark and a second by Paul Swagel. Any discussion? Andrea?
Just really a question, point of clarification. Thank you, sir. Just really a question, more so for clarification. So that, Dan, the motion with respect to bar structure is just simply in terms of whether or not we remain an integrated bar versus a bifurcated bar, and not getting into the nuances of what that bar structure will look like in terms of governance and so forth. Is that right? Yes. Thank you, sir.
Okay, so everyone understands the motion as clarified. Eileen?
It's the and tweaks part that is it's a little open-ended. For example, if you would think of it as a friendly amendment, I would vote for it, but with the understanding that there was going to be a review under Keller of the bar activities. So when you say tweaks,
Let me say what I think the motion is, and Dan can clarify it, because I think this is there's been discussion up to this point that we might send more than one or two suggestions to the Supreme Court, or three, or some minority and majority view. I understand this motion to be taking off anything other than the current structure, which means an integrated bar situated in Seattle in this building. I think Keller, I think, what do we do with the Supreme Court boards, I think within that big picture, we're going to continue to have that discussion because we haven't gotten to number 3. Am I understanding your motion?
Yeah, I mean, okay, we've spent close to 3 months debating kind of should we bifurcate, should we stay I mean, this will help us at least go forward with the one track and then look
Right.
at that.
Right,
Yes.
so I understand it to be, this will be our big framework in which we will start doing more work and what that looks like, and we'll have more motions and more discussions, because we haven't talked about governance, but rather than having 2 tracks, we'll have 1 track, and it'll be within that. And I think if this were to pass, there might be a big sigh of relief by a lot of people, at least an initial one, that we're not talking about something else other than at least working kind of within our big parameters of the current bar association. All right, are people comfortable with with that? Andrea, please.
I know I've been silent all afternoon, and I'm going to be a troublemaker. I appreciate the intent of the motion. My only sort of hesitation would be if we start to get into a very intricate discussion about the structure of the bar in terms of the governance, and then we're uncomfortable with that or not able to reach a consensus, and then I would say, well, hey, I think we should bifurcate then. So I know. Does that make sense?
I think it does make sense. I think we can vote on this motion now, and if our discussion takes us there, another motion could be made that may or may not get the votes to go down an additional path. But I think I understand the motion to be trying to focus us with 2 optional meetings, one that I've already indicated we're doing for sure, one that we're probably doing, but I really don't want to do any more than 2. So I am wanting with you to start narrowing it. We're not going to have any more we're not going to have any more guest speakers. I think we have satisfied everyone's desire for who we should hear from. I think we should address this motion now, and then I actually have some other points I think we might be able to decide today in the next half hour. So any other comments or questions about this motion? Okay. I am going to refrain from voting on any motions because I will take whatever this group wants me to the Supreme Court, and I will act on it there. So I think, but people can disagree with that thought, and if you do, I would welcome your thoughts on it. But I view myself as the chair and as the representative of the Supreme Court to be here to listen, to facilitate, to help. And so I don't want my voting yay or nay, although I would vote yay on this, just so you know, and that's the last time I'll do that. I'm just being funny, to influence you, okay? So I'm going to go ahead and call the question right now on Dan's motion, seconded by Paul. All those in favor, raise your hand, please. Okay, I have all but Hunter in the room. Kyle and Jane?
I raised my hand.
Aye from
All right, so I have
Aye from
all
Kyle.
the members except Hunter. She did. Right. So Fairhurst abstaining, Hunter voting no, and all the other members voting yes. Okay. All right. So the question I wanted to ask, based on what was said, was that change is not compelled by Janice. Go back to the, Andre, will you read me the first issue that's before us, that the court sent us? Or I didn't bring the charge with me.
Thank you. Number one is reviewing and assessing the structure in light of recent case law with First Amendment and antitrust implications.
Okay, so do we have any motions with respect to recent case law and whether that should impact saying to the Supreme Court what our response would be to that, sort of in light of this, reviewing it? And what I heard was that Janice does not compel change and that Keller is the law and that we should be focused on Keller. So that's just what I heard, but I am not making any motions. I'm just wanting to see if we might answer that question. If we can maybe get through 1 and 2, then we can really focus in on 3. Eileen, well, how would you say it?
Well, no, I believe back in the midst of time when we did Sherman antitrust, that we did have some recommendations for increased court supervision or review. So you might want to separate the two.
All right. Does anyone have something they would like to posit for the group to consider, including in response that would go to the Supreme Court? Andre?
So I believe Judge Corbett and his law clerk came up with additional oversight of the Supreme Court in relation to hiring, or it was considered to be a veto power. I think we probably need to discuss that and vet that a little further as to what the nomenclature would be. But certainly additional explicit oversight for decisions made by the individuals who have delegated authority so that it rests clearly with the Supreme Court.
So that's really dealing with sort of some of the antitrust and dealing with the market supervisors. So that might go into more depth with the sort of governance and the view. I've got Paul, Fred, and Mark. Paul?
Well, I guess, Andre, if you could just clarify what additional oversight by the court, and I guess that is toward antitrust issues?
Right. Well, so because we're talking about number one, the answer to that question. Yes. Yes. With respect to antitrust issues, I think it does dovetail into the governance question, but that's something that we haven't vetted, and I think we're going to return to. So, yes, on the antitrust.
So I might be premature in trying to move us forward, but I think it's still helpful to have this conversation and see if it'll help us move forward today or another day. I'm going to Fred and then Mark.
To refresh your recollection on the memo that I submitted, if someone makes a resolution or makes a motion on this, I think the simple motion could be, I'm not going to make it now because I gave you my research, But the antitrust issues are minimized, in my opinion, is if the Supreme Court had veto power over the termination of the executive director and of the disciplinary council. I think it's not one or the other, but both. Think about it, is if a friend of a BOG member is being disciplined by the Bar Association and the BOG could fire Doug Ende, that's not the kind of thing we will ever want to see. And that's not what's happening here at all. But those two employees.
Okay, I'm going to Mark, and then Dan Clark, and then back to Paul.
Okay, I have a motion, and with respect to the free association and compelled speech claims that are currently being litigated throughout the country, based on the presentations that we've received, the discussion among the members of the group, and the case law and decisional authority that we've reviewed, that the work group does not recommend any fundamental changes to the programs that the Supreme Court has determined, based on its constitutional authority, that Washington State Bar Association members should pay for.
Okay.
I second.
I would like to go to, I have a motion from Mark Johnson.
And can you repeat it?
Please don't ask me to.
I think Dory might be able to, and I think I might be able to. It's a motion under the free association and compelled speech clauses that, based on the presentations, the work group discussion, and case law, the work group does not recommend any changes to Supreme Court boards that the WSBA administers. There's a little bit more about...
And funds.
And funds. There's a little bit more about our...
Constitutional authority.
Constitutional authority.
You pretty much got it. It was a little verbose.
Margaret?
Apologies.
So is it the Supreme Court boards?
Yes.
I heard you say with the fundamental changes to the programs that the Supreme Court has determined.
Yeah.
Is that the same as Supreme Court boards?
So yeah, the Supreme Court board should probably not be the language. It's a fundamental change to the programs. I'll make it more clear, I hope. Administered and funded by the Washington State Bar Association, that there should be no fundamental changes to those programs or the funding of those programs at this time. Again, it's based on the current status of the Free Association First Amendment compelled speech litigation.
Okay, so the motion's from Mark and the second's from Andre. I would like to go to those who had their hands up beforehand, and then I'll come back to the motion. All right, so I have Mark spoke. I have Dan, Paul, Kyle, and Fred. Dan Clark.
Okay, so with regard to your comment, the BOG, we have, it's really clear in our bylaws that we have no hiring. I mean, we have the stuff for the ED, and that's it. Okay, so just, okay, so your hypo, okay, it's not accurate because we couldn't fire,
Right.
one right now, and
So-
and they're clear too. The ED has the right to file one with the court, and in fact did with the recent one. So.
Right, so Dan is clarifying that under the bylaws, the discipline cannot be fired by the BOG, and the ED can be fired, but has a right to appeal to the Supreme Court.
Right, and my recommendation was similar to the report that was done, about 4 years ago, which is slightly different. We can look at this language, but I think Dan and I could talk about that out of
Okay.
session.
Great, I'm going to Paul.
Well, Dan Clark clarified something that I was going to clarify, and I'll amplify his comment that I think the current status where the executive director can be terminated by the elected board of governors is vastly superior from a governance model than having the court have that first cut or have just an absolute veto right, or only controls that hiring and firing. The model that we have is consistent with governance in general. Having the members have that one elected role, that single elected role, is an important check and balance on balanced governance, on transparency, and I wouldn't tinker with that at all.
All right, I have Kyle.
Yes, thank you. I had the same thought that Dan Clark did, that we're really, especially when we're talking about disciplinary counsel, it's not really the person that we need to
Speak a little bit louder, Kyle, please.
I'm sorry. So with regard to the comment that Dan made, I agree with that. That was partially my comment. The other thing that I wanted to share was that, it's not really the person that needs to be protected for antitrust issues. It's the marketplace influence, and that's already being regulated by the Supreme Court. The Bar Association itself doesn't impose discipline. We present the case, and then the Supreme Court makes the decision. So under that scenario, whether we agreed or we voted, and we can't, but if we voted to remove the disciplinary counsel, that does not have any effect on the discipline that could be imposed by the Supreme Court. So I wanted to make that clear, and then I also wanted to second Paul's comment about the ED. And there is language there, and maybe we can talk about that, but I would think that we would want to talk about that before we have any kind of motion on it.
Right. We don't have a motion on that. We have a different Mark Johnson motion we'll get to in a moment. I'm going next to Fred and then to Eileen. Oh, did I miss someone? Oh, I put you on the list. Thank you. Thank you.
Mine's really a question, and I think it, depending on the answer, Mark, is the motion, we've taken out board.
Right.
Okay, my previous resolution, which I was going to make as a motion, I think yours is broader than mine. Taking out board, do you mean that the ATJ board, the support for the ATJ board that exists right now, if I vote for your motion, I'm voting for the support, the continued support of the ATJ board?
Absolutely.
Okay. So I believe that your motion...
I think that Margaret made a good point. Someone could misinterpret it as boards administered by the Supreme Court, but not funded, not administered or funded by the State Bar Association. That, the Certified Guardianship Board and a few of the others. So, yeah, these are the WSBA funded and administered boards. In light of the current, our understanding of the litigation with respect to free speech and association, that we recommend in the court that no changes be made with respect to the...
Is your microphone on, Mark?
Yeah.
Oh, then
I'm
you'll
sorry.
just hold it closer, because they were having trouble hearing you.
With respect to those those Bar Association programs, maybe that would be a better term, and the boards that the Bar Association funds and administers, that we recommend no fundamental changes be made with respect to the contribution by WSBA members of those programs and boards, which the Supreme Court has determined are part and parcel of the regulation of the practice of law, the improvement of legal services.
Okay, so that encompasses the resolution that I had, or at least part of it. With respect to the first part, I had two different pieces. It clearly covers the ATJ portion in the draft resolution that I put forward. So you answered my question on that. As for the other thing that we've been discussing, as to, I'll just say that I want to limit the discussion right now to what's on the floor to vote on, and you've answered my questions. As to the oversight what the BOG members would like to do and what other people I've talked to would like to do and looking at the various reports. That's something for further discussion. I just have to say that I disagree with several of the BOG members on that point.
So my understanding is the comments and the hands that were up that I allowed to, or called upon to speak, was based on their hands already being up before Mark made his motion when we got to him. Mark has a motion that I'm going to clarify before we vote on, but I am going to Eileen and Hunter, and then to the extent you are not talking about this motion, after you, we are going to be talking about this motion. Eileen.
Well, I thought we had started with the Sherman
We
antitrust,
did.
which I thought would be simple, but here we are. And so
Here we are.
what I think, and maybe I'll even make a motion, was that we had discussed, heard from Doug Ende, talked about the discipline process, and had some general recommendations for slightly more robust supervision by the Supreme Court, perhaps an annual report on the state of the discipline process and how many, there was an article in the...
Yeah, we get an annual report every year from the discipline.
And it was published in the Northwest Lawyer, but we had some modest recommendations, and that I would move that those, we would recommend the court take those steps just to review the process under the dental board case, that there is a sufficient obvious supervision by the Supreme Court of the discipline process.
Okay. Thank you. I would like additional motions, given the hour, to be sent to Dory in writing with precise language that we will send out in advance so people can think about it, can come up with their amendments, whatever they're going to do. So the ones, because I don't have that language in front of me, and
No,
I
I
don't
don't.
have that detail, and I would like us to have that when we go forward. But I think that next meeting, we can spend a lot of time kind of cranking a lot of this out, and I want you also to be specifically thinking about governance. So I'm going to Hunter, and then I'm going back to Mark's motion, and we'll go from there.
Wonderful,
Hunter.
thank you. And this does pertain to Mark's motion. Mark, I will be respectfully opposing the motion, and here is why. Just from a context perspective, I think to a certain extent, as I understand the motion, my position is a little bit governed by the vote that we just took a couple of minutes ago. But acknowledging that that has been addressed and resolved, and acknowledging that our recommendation to the court is going to be that we retain the unified structure, I'm not sure if it makes sense for us to vote on and decide your motion until we have addressed and resolved the more specific governance issues related to the Board of Governors and the Executive Director. So I will be opposing it.
Okay, so I'd like to clarify what I understand the motion to be, because there is a difference between, I think, programs and boards, and I'm not sure what programs are Supreme Court programs that are not boards that are administered and paid for. There might be some. I'm not aware of them. I'm aware of boards that the Supreme Court are under the Supreme Court. We have representatives from them here. We have others that aren't here that are also Supreme Court boards that the Supreme Court, in our orders, have ordered to be administered by the Washington State Bar Association and paid for by bar dues, which happens because they're administered. Those boards include the Practice of Law Board, the Access to Justice Board, the MCLE Board, the Triple LT Board. There's a fifth one. Does anyone remember who I'm forgetting? The Limited Practice Board. And then we have some that are not, where the Supreme Court appoints some people, but they're really part of the board, which would be Character and Fitness, Discipline Board. But the Supreme Court, ones by our order that we have done, are the five that I just mentioned. And I was thinking that that's what Mark was moving, was that the five Supreme Court appointed boards that are administered by the Washington State Bar Association and funded by bar dues, that there not be any changes. Am I correct, or is it something different than that?
Well, you're correct, but I think I also included the term programs. So, for example, the Committee on Professional Ethics, the WSBA Diversity Committee,
Those aren't by us.
right. But
So those would not be funded or administered pursuant to Supreme Court directive.
okay, perfect. I think your recasting or rephrasing of my inarticulate motion is much better. It's on. I'm just losing my.
He's muttering.
I'm
To
muttering
me.
to myself. Yes. Where do these people come from? Yes, Madam Chief Justice, I would be happy to vote on the motion as you phrased it. I think it's a smaller bite than I tried to.
You can include all those in a separate motion separately, but they would not be encompassed by the language that you limited your motion to.
Okay, let's do that, and then I think Madam Chief Justice is seeking written motions after this meeting, and I would much prefer, with respect to the other motions that I have, to bring those in writing after I've had time to thoughtfully pen them.
Thank you. Eileen, you had your hand up.
What were the 5 again?
Access to Justice Board, Triple LT Board, Practice of Law Board, Limited Practice, what did someone tell me? Limited Practice Board, and,
Character and fitness.
no, that's not character, it's MCLE Board.
So the Committee of Bar Examiners is not,
It's a bar committee. It is not a Supreme Court committee. Yes, Doug?
The disciplinary board is technically a Supreme Court board, which is created by court rule and appointed by the court.
All right, so the disciplinary board would be included. Thank you. Am I correct, Jean, that character and fitness is not?
Operated under court rule, but they are appointed by the Board of Governors. I think that's a tweak that might be considered.
That might be a tweak. All right. Court-created boards. Thank you. Thank you, Dan. Thank you, Andre. Access to justice, disciplinary, limited legal licensed legal technician, limited practice, mandatory continuing legal education, and practice of law. Those are the 6 Supreme Court appointed boards.
6?
Right, because I added the disciplinary board.
Okay.
We are not. But it might be a tweak, but we are not at this time. The rest are court-created boards, but Board of Governor appointed, and then there are other discipline-related entities. But the court-created boards that are administered, that we have ordered to be done here, are those 6.
Okay.
All right? Any further discussion? Are people comfortable voting? Eileen?
Well, I think there was a second, but it was before
It
there
was
was
from Andre.
It was before there was a list. But to me, this is half the issue under Keller. So if we just say we're not going to talk about it, then I don't think we really have anything much else to do. I think in the last 5 minutes of the meeting, to vote on something this sweeping for closing, from my perspective, discussion of what other things the court should be doing, I'm not prepared to vote on it. So that's my take on this.
Okay, Mark?
I'm not prepared to table the motion. If there was a motion to table, and there was a second, and it passed, that would take care of it. But I'm not going to voluntarily pull the motion with a second off the table.
All right, do I have it? I have Andre, I will call on Andrea.
Thank you. So moved. Motion to table.
Second.
Motion to table, I have a second from Eileen. All those in favor, raise your hand. 3. Opposed? Motion to table fails. All right, so Hunter.
Voted in favor.
Oh, Kyle and Jane, how did you vote on the motion to table? And I forgot I wasn't
Yes.
voting, so never mind me.
Kyle.
Kyle, your vote?
Yes.
Motion to table, you vote yes? All right.
Yes.
Jane, your vote on motion to table? No, Jane. Okay, so I have at least 4. I had 4 to table, and I had more than that not to table. The other 4.
That's close enough.
My 4 were Andrea, Eileen, Hunter, and Kyle. And Jane abstained, and I abstained. All right, Hunter, your hand was up.
So I think we are back then to Mark's motion.
We are.
And I guess I would just say that maybe it's just me, but I'm not sure how we vote on Mark's motion to pass it in an informed fashion without, again, having addressed and hopefully resolved in some fashion the questions of governance that are out there with regard to the Board of Governors and the Executive Director. So I guess I would say that I'll be voting no on the motion. Thank you.
Andrea?
Thank you. Is it on?
Yes.
Okay, whether I vote today or when the next time we meet, I mean, I would be voting in favor of your motion. I'm just trying to model some of the principles that we're actually trying to sort of address later on when we get to the issue of governance, which is process and transparency and so forth. So that's why I was, I made the motion to table. I appreciate the effort to get this accomplished, but to the extent that it only half addresses some of the other things that Eileen mentioned, I think that is is significant. So again, whether we vote today or not, you have my support. But again, to the extent that the next conversation is going to be about the governance piece, I think we can sort of model some of hopefully the best practices that we'll be trying to encourage later on.
Mark Johnson.
Well, I do see I understand, Hunter and Andrea, I understand your concerns, but I see this as entirely separate from examining the bar governance issue, which we haven't even started on yet as far as I'm concerned.
Well, I guess we're going to vote here in a moment. It would be my hope that we would say, if this passes, which I'm expecting that it will, that these court-created boards should continue. The work group, the motion actually says not to recommend any changes to them. That was the language you used. And that is much more encompassing than being able to perhaps tweak it, which is what we left open under Dan's motion. So recommending not any changes, which was the language that at least I wrote down, and is that what you wrote down too, Margaret? Yes. So that is what you would be voting on. Okay? I'm going to call on Andrea, and then I'm going to call on Andre. And then I'm going to tell you we have 1 minute, so we're going to either vote or not vote.
And my last comment will be, again, you know where I stand on it, and I would support it. But that also then precludes us from making changes that could actually improve or sort of have positive impact upon it.
Unless someone who voted in favor of it voted to reconsider, and then we could reconsider it.
Understood.
Andre. Withdrawn. All right. I have a motion to not recommend any changes to the Supreme Court appointed boards, the 6 that I listed. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6. Opposed? Opposed, 2. Some people aren't voting. 3. 6-3. So my 3 are Dan Clark, Hunter, Abel, and Eileen. And on Kyle, your vote?
Yes.
In favor? Jane, are you still on the line?
Yes,
So 2
and
yeses.
I vote in favor.
The vote passes 8-3, with me abstaining. Okay, the meeting is adjourned. Please send your motions, your thoughts, especially on moving through our charter and governance. Okay, our next meeting will be on July 8th from 9 to noon here, and Dory.
Right, and because July 8th is the Monday right after the 4th of July weekend that many of you may have plans for, if you have a chance to get any motions to me by noon on July 2nd, that will give us a chance to publish them to this group and for Margaret and Ginny at the Supreme Court to post them online so that they can be visible as part of the meeting materials. So if you can send them by noon on the 2nd, that would be ideal.